Good morning, everyone, and welcome to this 39 Essex Chambers seminar on the Fire Safety Act after its first year since enactment. I'm delighted to chair this seminar, and I want to just tell you a little bit about how it's going to work. The fire group at 39, as some of you will know, but you may all not know, is a set of chambers that has 4 groups: construction and commercial, civil liability, public, planning and environment. And so you can immediately see that fire spreads across all 4 of our groups. And some of the speakers today, I'm telling you about them in due course, have formed a fire group of which we are all members to deal with this area of work which crosses over so many areas of what we do. And we're able to this morning have 6 talks. I hope that I'll be able to introduce them and to manage them so as we get through the time. We did do a rehearsal of this in a live session that I know some of you wanted to come to, and we nearly got to time. I've given my colleagues stiff lectures to ensure that they repeat their time-saving process. If anyone has any questions, put them in the chat and I'll see if I can work them into my questions to the speakers. If we can't, then we'll endeavour to answer them afterwards. I'm going to go straight on then to the first of the 6 of the expert speakers that we have on our team today. The first is Kerry Bretherton KC. She joined Chambers recently, like me, and joined the fire law group on joining Chambers. Kerry has, and this is not in her CV that she wrote, but I'm going to say it, a stellar reputation as a property silk. She's been in the Supreme Court and Court of Appeal, and she litigates and advises in all aspects of property development and commercial disputes, and therefore fire and building safety is bang in the centre of her work. She has a sideline of writing books. She writes 2 books. She's the co-author of the Electronic Communications Code, a practical guide, and then she's a contributor to Service Charges and Management, 5th edition. Both of those are, I can assure you, bestsellers, and I'm sure that we can come to some arrangement to get you a discount, an even bigger discount if you wanted to buy 2. Kerry, who is going to talk to us, as you would expect, about the leasehold side of the fire dispute. And the introduction to her talk is that the Building Act has, as you will all know, a substantial impact on leaseholders' liabilities. Kerry is going to first of all talk to us about the leases to which that regime applies and how they are defined and what they have to comprise so as to benefit them. So can I first of all ask the rest of my colleagues to depart, and can I then ask Kerry and to come back, only to depart for the moment, and for Kerry then, if she'd be kind enough to introduce for the webinar, introduce the question of the qualifying lease.
Thank you very much, Paul, for that kind introduction. A qualifying lease and the concept of it is absolutely fundamental to understanding some of the issues for leaseholders. And there are a number of different elements for the purpose of section 122 to 135 of the Building Safety Act and Schedule 8. First of all, it's necessary that it's a long lease, namely one granted for more than 21 years, and that's irrespective of if it can be terminated at an earlier stage or is subject to re-entry or forfeiture. Secondly, it must be of a single dwelling. The obvious example is of a flat in a relevant building. A relevant building is defined in section 117 of the Act and is namely a building which either is over 11 metres high or has more than 5 stories, subject to certain exceptions. The third element is that the tenant under the lease is liable to pay a service charge within the meaning of section 18 of the 1985 Landlord and Tenant Act. There are also timings that are important. The lease has to have been granted before the 14th of February 2022, And from that date, which is described as the qualifying time, the dwelling was a relevant tenant's only or principal home. And that makes me reminisce back to the days when I was a baby barrister dealing with housing cases and the concepts under some of the old social housing legislation of only and principal home. And I can imagine us having to reproduce some of those authorities in arguments in due course. Next, that the relevant tenant did not own any other property, whether as a freehold property or a tenant under a long lease, or if they do own another property, that it owns that they own no more than 2 dwellings in the United Kingdom, apart from their interest under the lease. And the final point I'd make under this sort of heading is that qualifying lease status will transfer to the new owner of a home upon sale. Paul, you're on mute.
Getting it wrong the first time. There we are. I'm very keen that no one should hear my dog barking in the background. Are there any ways that freeholders can get round Schedule 8?
No, unsurprisingly, Paul, Parliament has prevented that. Any covenant or agreement which purports to exclude those provisions is void. And for people's references, that's pursuant to paragraph 18 of Schedule 8. Furthermore, paragraph 10 of Schedule 8 provides that if no service charge is payable, no costs in relation to that thing are to be taken into account in determining the service charge, or indeed even met by a reserve fund.
I mean, I think it's right, isn't it? Over the years, there's a big industry in the avoidance of arguments to get yourself out of the impact of legislation and or common law principles, and the mood both of Parliament and the judges has very much changed. And I think that obviously that doesn't mean there isn't scope for lawyers to produce arguments, but I think that it's all part of a trend that managing to get yourself out of the impact of something that was intended to affect you is going to be more difficult rather than easier.
I entirely agree. And when you think of the context of this legislation, and obviously some of the other speakers are very well known for being involved in the Grenfell inquiry, and they can deal with that better than I can. But the underlying purpose of this legislation has been a direct response to that tragedy. And Parliament has made it clear that people can't try and extricate themselves from the provisions. And indeed, that really sets the whole context for the legislation, and indeed some of the quite extraordinary aspects which are retrospective with regard to other elements.
And in what situations, just to sort of move on to conclude, are costs irrecoverable from leaseholders?
There are a number of circumstances in which they're irrecoverable. The first is where a landlord or an associate's responsible. That's paragraph 2 of Schedule 8, which prohibits the recovery of costs of relevant defects. They, of course, being defined in section 120 of the Act, namely, in summary, those causing a building safety risk from fire or collapse that a relevant landlord is responsible for, or an associated a person associated with the landlord's responsible for. And responsible for means, in the case of an initial defect, the person who was in a joint venture with a developer or undertook or commissioned works relating to the defect, and in any other case, the person who undertook or commissioned works relating to the defect. And then an associate's defined in section 121. I haven't got time today, keeping to your strict time limits, to talk about it, but I think one of the really interesting arguments we're all going to be having is about the definition of associated companies in due course. I think that's going to be one of the core area of arguments. Just by way of an example, the costs which are not likely to be recovered under this heading are likely to include remedial works and also interim protective measures. We all know about waking watch costs, sprinklers, those kind of provisions. Secondly, I can deal more briefly with cladding. Under paragraph 8, no service charge is payable under a qualifying lease for cladding remediation, namely removal of cladding, which forms the outer wall of an external wall system and is unsafe. And with regard to that, 2 points to comment. First of all, I can see arguments about what the definition of the outer wall is. And also I can see arguments in those cases where it's argued that cladding is being removed for reasons other than safety. Third category is the net worth of the group. If it's more than n times 2 million, in which n is the number of relevant buildings within the landlord group or any part of it, and that's then defined as the relevant landlord or any person associated with it. Importantly, that excludes social housing providers and indeed local authorities. Fourthly, there are those categories where we're dealing with low value leases, those under 325,000 in Greater London and 175 elsewhere. Finally, professional and legal charges relating to liability for relevant defects. Under paragraph 9, they are precluded if they're legal or other professional services relating to the liability or potential liability of any person incurred in relation to a relevant defect, including legal advice, arbitration, mediation. On that, I just want to add one point. That's proved to be quite an interesting earlier area of debate on which I've advised, because there are arguments about the funding of the very types of orders that one would want to seek under this legislation, for example, in relation to management companies. What I believe this is directed to is preventing the landlord from recovering by the back door, but it may well be we see some interesting case law on that point.
And just finally then, what limits are there on the service charge which is payable?
There are specified limits at the moment. If the service charge exceeds a prescribed maximum value in the 5 years up to 28th of June 2022, the sum payable is limited to 15,000 in Greater London, excuse me, or 10,000 elsewhere. If the flat's worth 1 to 2 million, that sum is then 50,000 and 100,000 in respect of flats over £2 million. There are special rules in relation to shared ownership leases, and furthermore, by paragraph 7 of Schedule 8, the service charge must not exceed 1/10 of the permitted maximum Regulation 6 in relation to a relevant service charge, namely one under a qualifying lease.
Well, that's a tour de force, highlights for me the complexity of it. The fact that you managed to explain such complex things so clearly is remarkable, but it does remind us that we are dealing with detailed, precise regulations, which very interestingly, I think, hit general principles of law. So you've got this interface between the approach of the courts generally, and then these complex provisions. So I think that's going to be an interesting ride for those of you who are specialising in that area. Thank you very much. Can I move on then to the second? Thank you very much, Kerry. The second of our speakers, who is Nicholas Higgs, another member of 39 Essex Chambers. His route to 39 is different. Prior to coming to the bar, Nick was a civil engineer at Arup for 15 years, starting out as a bridge engineer, and segueing into project and commercial management, and finishing his career as secretary to the firm's group board. He's been involved in lots of defects cases involving fire in his career at the bar, some of which have been reported. His main claim to fame, however, is that he is a contributing editor to Wilmot Smith on Construction, the 39 Essex construction book. And for those of you who are interested, the next edition will be Wilmot Smith and Darling. So he's going to have an even bigger role than he realizes. He's going to talk to us about the two areas. Well, firstly, the general difficulties of proving a fire claim, and secondly, sampling. Bear in mind that fire stopping, for example, will very often involve many allegations of breach, and how sampling can be used to help prove that. So, Nick, good morning. I'm going to ask you first, if you'd be kind enough to tell us, what it is about fire safety defects claims that make proving them particularly challenging.
Thanks, Paul. Good morning, everyone. So from something complex and quite black letter law to something a bit more prosaic, which is the type of defects we're actually seeing in the cases that are coming through. I think there are probably three things that make it particularly challenging. First is the type of defects that we're talking about. Typically, these are either in the cladding, so things like the cladding itself, or cavity barriers if it's a rain screen, or fire breaks if it's a continuous insulation material, or they're inside the building and they're things like the passive fire protection that's been applied around services and that sort of thing. I think the issue with these type of defects is they're hidden within the building fabric. And unlike a roof leak, where you know it's leaking because you're getting dripped on as you're sitting at your desk or lying in bed at home, you don't know about these defects because they don't manifest themselves unless you have a fire. And obviously it's too late if that happens. So the second difficulty about that is where these defects are typically located. They're in hidden areas of the building and often in inaccessible areas of the building. So if it's located behind the cladding, that's not a straightforward location to investigate. If they're hidden within the partitions, up in the ceiling voids, hidden under floor coverings, again, these are not easy places to access within a building. And because you don't know where the defects necessarily are and whether the construction is or defective in any sense, you need to undertake some investigations. And that's the third issue that makes it difficult, is that in order to prove a claim, you're going to have to investigate these defects. And unless you've already taken off all the cladding on your building and replaced it and made an excellent record of what was discovered whilst you were doing that, you're going to have to undertake some investigations. And they're expensive, they're disruptive, and interfere with the use of your building. And clients rightly want to limit these to the extent that's necessary. So is it going to be practical to identify every single defect that's existing in a building? Probably not. The example on the slide is a typical kind of fire stopping detail that you might discover when you start opening up the building. And it raises lots of questions, which really you're going to need some expert advice to answer, because you or I, Paul, looking at this, we can kind of tell what it looks like. There's a bit of dodgy foam poking down a hole around a soil pipe. But whether that's meant to be fire stopped, whether it's meant to be fire stopping foam, whether it's been applied correctly, what it looks like from above are all questions that we're going to need some expert help to look into. And we're probably not going to want to try and find every single example. We're going to want to find representative examples and then extrapolate those to the rest of our building.
An extrapolation, there's quite a lot of, this has become very much a hot topic, as to, an extrapolation starts with, doesn't it? It starts with how have you got to plead your case and how have you got to prove it? So could you perhaps help us as to where the courts have got on this journey and whether you need statistical evidence, all of that. So can you just give us a thumbnail sketch at the time available of where we've got to on that? Yes,
I think it is common, and the mood music from certainly Lord Justice Coulson and the Court of Appeal, it's increasingly common. He put it like this: the essential proposition is that if the sampled allegations are found on the balance of probabilities to be properly representative of a pool of allegations as a whole, then your detailed investigation of that sample can be extrapolated into a result in respect of the whole pool. So you've looked at some examples in detail, you've proven that those examples are representative of the whole, and then you're asking the court to infer that the whole is defective. And he was quite encouraging of this approach, really. Some good news for all of us litigators. He said in BDP and Standard Life, the beginning of the quote that's on the screen, "The days of the court requiring parties in detailed commercial and construction cases to plead out everything to the nth degree are over," which I thought was excellent news. It's not sensible, it's not cost effective, it's not proportionate. And then the parties are duty bound to proceed in a sensible and proportionate way. So,
I mean, I have experience in other jurisdictions of arbitrators taking a tougher line about that and saying, effectively, you've got to plead out the whole case, then just pick your samples and then produce your statistical evidence to show that those samples are likely to be representative. Now, that's obviously the hard end. And I think what you're saying is there's a rather more pragmatic approach in the courts here.
yes, I think that's right. I think it's slightly unfortunate if you are in front of an arbitrator who takes that view. I think the difference, obviously, we have in the courts of England and Wales is that the overriding objective means that proportionality in trying these cases is going to be a key issue. So in BDP, if all of the allegations had been fully pleaded out, there'd have been an extra 60 odd lever arch files just of pleadings. And I think the view of the court was they weren't interested in having to read through all of that, and it wasn't an effective use of the court's time and the parties' resources. There are some caveats to that as to when it's going to be suitable. And in the Link case of Standard Life and Bleeds, Mrs. Justice Kerr said that it's going to be appropriate where you've got performance which has been, or poor performance which has been repeated. So if the defendant's mass produced the same error, so for instance, it's been the same subcontractor doing all your PFP, then that's the sort of case where it's probably going to be useful. If it is chaotic or close to non-existent performance, then that is not the sort of case that's going to be suitable for extrapolation. But
and what happened in the Cumbria Potel cases?
Well, exactly. These are two warning notes to sound. Both of these cases are ones where the judge said that extrapolation and sampling was a suitable way of proceeding, but in neither case was the case made out. And what seemed to be the issue in both those cases was either too limited a sample or the sample that was chosen being unrepresentative. Amy and
it's a big risk to take, because if you choose your sample at the start and get it wrong, then you get to trial and you fail. Now,
yes, and I think the important issue is to recognise that this is the approach you're going to take in your claim, and to approach your investigations and your sampling on that basis. So from the
and your case management.
Yes,
you've got to get it set. You got to, because the thing is, you got to think about getting it set up in advance.
Yes.
And if, for example, your opponents say that they want to call statistical evidence to prove the unrepresentativeness of your sample and start to ask for permission to do that, then the red flag is waving, and you've got some quite difficult forensic decisions to make there.
Yes, I think that's the case. But I think the most difficult position to be in is to decide after you've already done all your investigations that you're then going to try and run the case on the basis of sampling. And it might have been that your investigations have focused on the areas you suspected there are defects. So there's already a bias incorporated into the sample, and that's when it starts to become problematic.
Well, the risk of sounding a bit old school, you wouldn't start with the ones where the area where you thought there weren't any defects, would you?
Well, exactly. Why am I paying to open that up?
Yeah, I'm paying to open that up because I know there's nothing there. That's the sort of thing clients love. I just give a couple of minutes, if you wouldn't mind, on just any pointers to what the hot issues in this area at the moment for the audience's benefit.
Yes, I think, well, one of the issues is that all of this is going to rely on experts. Firstly, because you need an expert to recognise these things in the first place, and then you're going to need the expert to opine on the consequences, etc. And that does raise the issue of mixed fact and opinion evidence, because your expert who's going and looking at something, taking a photograph of it and describing what it is essentially providing the court with evidence of material facts. It's not a matter of opinion as to what he or she saw. And so I think particularly legal advisors need to be particularly aware of that issue and try and keep the fact and opinions evidence separate. And it's something that comes up again and again, particularly in respect of when you might need to change your expert, but also in respect of the disclosure of the material that experts have produced, because that evidence of primary facts needs to be in front of every party's expert. So they've got the same information on which they can then base their opinion.
Can I mention one glitch there before we finish? I was involved in a case when the experts met and did without prejudice meetings and just made various tests and discovered various facts about the building during those without prejudice meetings. Unfortunately, the decision of the Judge Humphrey Lloyd about the admissibility of all of that has not survived. But I can tell you that his view was that things that are discovered on expert meetings, if they're without prejudice, are not capable of being subsequently referred to because you can't disentangle them from the meeting. And the meetings without prejudice and privileged, and therefore the investigation can't be disentangled. So I think that the modern trend has been to formalise and to sort of remove those sorts of risks by rule by ensuring that experts do work according to a pre-agreed and transparent procedure. And I think there'll be a lot more of that over the next few years.
The key phrase that keeps coming through in the decisions is about equality of arms of the experts, and there being a level playing field between all the experts. And just to finish, that was the point that came up in Dana and Freudenberg. There was an application on the 7th day of trial, just before Freudenberg's experts were going to be cross-examined, to exclude their evidence. And because of various deficiencies in the way the expert process had been run by the defendants there, that was granted by Mr. Justice Joanna Smith. So FST had no expert evidence before the court because they failed to comply with the rules, because there needed to be that level playing field. So I think that's just a happy note to finish on a Thursday.
Well, I'm not going to let you quite finish on that because well, you're up against time, but I can't let you go without talking for at least one sentence about clean and dirty experts.
Yes. So, and the issue here is that because you're having experts involved so early on to identify these defects, essentially they're acting as your advisor at that point. So their duty at that point is to the client, not necessarily to the court. If they're then later instructed as a Part 35 expert who's going to provide that expert evidence to the court, then their duty changes really, and they become primarily answerable to the court. And there can be a little bit of tension in that transition, and care needs to be taken. So clean and dirty is the Australians' way of putting it. You've got your clean experts who you put up in front of the court, and your dirty experts who you keep in a cupboard advising you as to what they really think about your claim. And
well away from your clean experts. Thank you very much indeed.
Thank you,
Nicholas. Thank you very much. Our next speaker is Grange KC. Kate was appointed one of the lead counsel to the Grenfell inquiry in July 2017, 1 month after the fire, when she was just newly King's, or then in those days, Queen's Counsel. Since then, she has, and we are very much indebted to her for the public interest, dedicated herself to that very important inquiry and has effectively worked full-time on it since. We hope one day that she will return to practice in the commercial construction and public law field, in which she excels, and excelled particularly before she started the inquiry. And she's going to be talking, and I'm delighted that she's found time to join us this morning, and thank you, Kate. One of the things that comes in the Building Safety Act, of course, are causes of action, new causes of action about the quality of construction products. And that's a major new development. Kate, could you just give us the background to that?
Yes, thanks very much, Paul, and good morning, everybody. So it is important to think about the context and the background to these new provisions. Following the Grenfell Tower fire, the first thing we had was the Hackett report in May 2018. And she identified that the process for testing and certifying products was disjointed, confusing, unhelpful, and lacking in transparency. And that last theme about transparency, we peeled back a layer when we looked at module 2 of the Grenfell Tower inquiry, which focused really heavily on the manufacturers of the external wall products that were used at the tower. That evidence was heard in late 2020, early 2021. The evidence that was adduced in the inquiry has been described in a recent report as shocking in terms of what it revealed about manufacturers and their testing and their marketing of their products, and also the third-party certification of products. The government reacted quite quickly to that evidence and announced that there would be an independent review of the construction products testing regime. Then in April 2022, the government published a fact sheet on a new national regulator for construction products. That was withdrawn on the 25th of July 2022, but provided quite a lot of insight into what's been planned in this area, including providing more market surveillance, oversight, more enforcement of strengthened construction product regulations, etc. And then in June 2022, we saw some very significant developments in the Building Safety Act itself. A raft of provisions have been brought in which are relevant to construction products, including under Part 5, powers for the regulation of construction products, the introduction of an independent reviewer to assess the effectiveness of the regulator in the system every 5 years. Under Schedule 11, the Secretary of State has wide-ranging powers to make regulations changing the system by which construction products are currently assessed, marketed and regulated. They're going to be known as the construction products regulations. And those will include provision for a list of safety critical products and also require construction products to be otherwise safe products as defined in the Act. The new national regulator for construction products is going to be part of an expanded Office for Product Safety and Standards, the OPSS. And then there are, I'm going to come to them in a moment, new civil causes of action in relation to construction and cladding products. Also new criminal offences for breach of the new regulations and powers for an enhanced enforcement regime. Now, there are still a number of developments to come in this area. It's very much a rapidly moving topic. The first big area is that we still don't have the details of the secondary legislation, the construction products regulations. There was a draft briefly published and then withdrawn. We don't have those new regulations yet. And that will probably be informed by a recent, very interesting report that came out following this independent review of the construction products testing regime. That was done by Paul Morell and one of our fellow barristers, Annalise Day KC. Now that report was published on the 20th of April 2023. It makes for very interesting reading. It's a very comprehensive report. And just a few highlights from it. It notes that only construction products for which there is a designated standard are covered by the old construction products regulation regime. And the anecdotal estimate is that that only accounts for about 1/3 of all construction products in manufacture, leaving about 20,000 to 30,000 products completely unregulated. They note that there isn't actually a UK specific system for testing the safety of construction products. Many standards, they note, are outdated, inconsistent, or non-existent. And they note that enforcement has been almost totally non-existent in this area. So manufacturers have practiced in the area of construction products, their testing, their safety, in this completely unregulated space. Now, in terms of next steps, we can anticipate that the government will issue a consultation on their proposed new construction products regulations. It was government's working assumption that the new regime would come in 18 months after the Building Safety Act came into force. So that would have been October 2023, but that looks extremely doubtful given progress to date. And the big headline takeaway is that overall this new regime is going to have a very significant impact on trade, as has been acknowledged in the Building Safety Bill before the Act came in. And the costs of suppliers are likely to increase hugely as a result of new compliance costs. So then I'm going to turn to the new causes of action that we see for construction products. And these are in sections 148 and 149 of the Building Safety Act. And here we've got section 148. What these sections do is enable a person with a relevant interest to bring a claim against a supplier and or manufacturer of a construction product. This is section 148. And then we'll look in a minute at section 149, which are cladding products. And I've highlighted here for you the essential tests. A relevant legal interest will essentially be a legal or equitable interest in the dwelling or the building if it contains more than one dwellings. And you can see from the parts that I've highlighted in bold that basically the scheme of this is that if someone fails to comply with a construction product requirement as defined in the Act, or makes a misleading statement about a product, or manufactures a construction product that's inherently defective, and then that's installed in, applied to, or attached to a relevant building in the course of works, if it renders that building unfit for habitation, you have a cause of action in relation to
echoes of the DPA on that.
Very much echoes of the DPA, exactly. That unfit for habitation test we can see in there very clearly. So that's section 148. And if we look at what 149 now, this is specifically in relation to cladding products. It's exactly the same scheme with a few tweaks. So the same tests are applying here. Note that these causes of action offer a more expansive test for causation than the traditional but-for causation tests. And there may be a parallel here with the recent TCC judgment in the Martlet Homes and Mullally case, where it was found that a claim could succeed where the defective installation of a cladding system was an effective cause, but not necessarily the but-for cause of the loss. So that's an interesting feature of these new causes of action. In both cases, the person referred to is going to be liable to pay damages to a person with a relevant interest. And those damages will be for personal injury, damage to property, or economic loss suffered by that person as a result of the facts referred to in these sections.
I mean, you see the common law, which has gradually been taking all these causes of action away, one by one, slowly, gradually. Back in, they all go in one big hit.
Exactly. And then a really big kind of theme of the Act, and we see it in other areas as well, is about limitation. For section 148, just construction products generally, it's 15 years prospectively from the date on which the right of action accrued. For this section we're looking at now, 149, it's 30 years retrospectively, reducing to 15 years prospectively. That's new section 10B of the Limitation Act 1980. So
it's hilarious when you think a 15-year prospective limitation period is a slackening, isn't it?
Yeah, exactly. So, I mean, what this really means is if you've got a cladding case, you want to be, and someone may have to be picking up the tab for cladding, you want to be looking very carefully at what the manufacturer was doing in relation to that cladding, what statements was it making in their marketing, what statements appeared in third-party certification, because in the Grenfell Tower inquiry, we've found on a number of occasions that even in what looks like quite authoritative certificates, false statements have been made about products, which have then directly led to them being put on buildings.
Well, that's brilliant. Thank you very much indeed. I think this is a really fascinating new area where I think there's going to be, I think that some of these areas that look big at the moment, they're going to look massive by the time has gone on. Thank you very much. Our next speaker is Samantha Jones, who is one of the co-founders of the group. She too has been involved in the Grenfell Tower inquiry. She was senior junior counsel to Richard Millett, who many of you will remember seeing on the television, in the area of fire safety and fire risk assessment and the actions of the London Fire Brigade. She's therefore has considerable experience, which she's carried on since leaving the inquiry team. And she's going to talk to us about remediation orders and remediation contribution orders. And I'm going to ask her if she'd be kind enough just to introduce this quick session by reminding us what a remediation order and a remediation contribution orders are. Sam.
Thanks, Paul, and good morning, everyone. There we go. I think I froze there, but thanks and good morning. So yeah, just a quick whistle-stop tour, because I'm sure you're all familiar with these provisions now, but the remediation orders and remediation contribution orders in section 123 and 124 of the Building Safety Act is something that we're seeing is giving leaseholders and landlords an immediate remedy to remedy defects and building safety defects that are causing fire safety risks on a building. And that's certainly something that's coming through through the courts and through the tribunal now. So remediation orders, you can see on the screen there, is an order that can be made on the application of an interested person requiring a relevant landlord to remedy specified relevant defects in a specified relevant building by a specified time. So there's a lot of definitions there, but the crucial points to take away are that an interested person, there's a whole host of people who qualify, but what you're probably seeing and we're seeing is that most often it's the persons at 5D, a person with a legal or equitable interest in the relevant building, like your leaseholders or your freeholder, who is seeking a remediation order. In terms of the type of building that this applies to, it's good to be aware of the fact that across the BSA, there is lots of different definitions of your relevant building. It's not just the buildings over 18 metres, although the fact that the Building Safety Act was brought in to try and remedy the Grenfell issues. And in relation to remediation orders and remediation contribution orders, it applies to buildings that are at least 11 metres in height or has at least 5 stories. And then in terms of what your relevant defect is, again, the definitions slightly differ across the Act, but in relation to sections 123 and 124, you'll find the definition is here in section 120 subsection 2. And it's anything that arises as a result of anything done or not done, or anything used or not used in connection with relevant works and causes a building safety risk. And what's important to know is that the things done or not done in relation to the works is for anything that was done at any time in the 30 years prior to this section of the Act coming into force on the 28th of June last year. So wide open in terms of your works that now can fall within this Act. Finally, then, something to look at when we're looking at all the definitions is what's a building safety risk. And this is really important to have a good understanding of. So a building safety risk is a risk to the safety of people in or about the building arising from the spread of fire or the collapse of the building or any part of it. So that's your remediation order. Your remediation contribution order has the same definitions, but the remediation contribution order is one that will be made only if a court considers it just and equitable to do so, and more on that later. But then the remediation contribution order can be made to require a specified body, corporate or partnership to make payments to a specified person for the purposes of meeting costs incurred or to be incurred in remedying relevant defects. And what the purpose of this provision does is twofold. Firstly, it gives landlords the right to claim the cost of remedying defects, fire safety defects in buildings from the developers under the kind of government's developers pay agenda that they are pushing through since Grenfell. But where the developer doesn't step forward, the other purpose of this provision is that it allows for leaseholders to compel a landlord to carry out the remediation works. And you'll see that's because an order can be applied for against a body corporate or partnership, and that includes a landlord person who was such landlord at the qualifying time or a developer. You're on mute, Paul.
I've done it twice. I turn you all off and I do it myself. I apologise. Twice, there are some cases beginning to trickle through the system. Could you just give us a very quick thumbnail sketch of it?
Yeah, exactly. So we've only seen one case come through in terms of actually being litigated in the tribunal. But what we're seeing when we're advising on these kinds of cases with remediation orders, remediation contribution orders, is kind of two practical issues that is, I think, good to be aware of. So firstly, it's about the type of defect that's being identified. So what we're seeing is that particularly leaseholders, when they're seeking remediation orders for costs of work, they are often including a whole host of defects that don't all necessarily cause a building safety risk. And that's why I said it's important to look at what a building safety risk is, because you need to be able to identify that that defect will cause fire spread in your building or collapse of any part of it. And often you're seeing claims for cladding and defective cladding that, you know, is often made out that will cause a fire safety risk, but then also, oh, the balcony on the roof or the roof materials are also not compliant. And that might be the case. It might be that they were defectively built, but it's, you know, in certain situations, it's unlikely that they'll cause a building safety risk. So that's the first issue we're seeing. The second issue we're seeing is that the expert evidence that is being used to support these claims is sometimes, sorry to any experts on this call, but fairly shoddy. It can be vague. It doesn't actually detail whether the defect that they've identified does actually cause the building safety risk. They often sort of caveat it by saying that they haven't been able to do an intrusive inspection. They haven't been able to look at documents about the construction of the building or the manufacturer's documents from the time when the building was constructed or converted. So, you know, understandably, they don't want to kind of put their neck on the line.
I think what will happen is we'll get a TCC case and an expert will get a good whacking from one of the judges in either direction, and it'll all be on there. Well, thank you, Sam, very much indeed for that. Just in one sentence, do you think that there's going to be a volume of these cases coming through in the next few months, years, or how do you see it panning out?
Yeah, I do. I think we're seeing more and more, particularly leaseholders, using this as a provision to compel their landlords, and landlords subsequently trying to claim against other landlords or developers to make sure that the costs of works are remedied. Because although the government said actually most of your developers should have signed up to the Building Safety Fund and the pledge that they issued last year, actually I think you'll find there's a lot of smaller developers who haven't signed up to it and will, you know, still be solvent or be able to be claimed against under the associate test, and they will be brought into the fray.
Beautiful segue, if I may say so. Thank you very much indeed for that. For David Sawtell, who's going to talk to us about the developer remediation contract and the responsible actors scheme. David is a member of 39 Essex and has been involved in a number of cases. He's involved in one of the first cases under the Remediation Act. It's a sad story for me because I was to be instructed to lead it, and I asked a few details about the development and the names of those involved. No one knew the names of those involved. They mentioned the name of the development, and I had a sudden ghastly feeling that meant that I had actually advised one of the contractors on the original project. So David then took on this case himself, and he also has a strong academic background, to our great admiration, and he's recently written with Peter Coulson the history of the technology and construction course in its 150th anniversary. So who better than to give us 7 minutes on the developer remediation contract and the responsible actors scheme. David, would you just be kind enough to introduce it by telling us what that contract is and what the responsible actors scheme is in about 2 minutes?
Yes, I can see the time is slipping away. Again, this is 32 pages of detailed regulations. So it's something you have to go in and digest afterwards. But the heart of it is a developer remediation contract. So in January 2022, Michael Gove wrote to leading major developers asking them to sign up to what was called the developer pledge. So they'll take responsibility to performing, carrying out remediation on buildings over 11 meters in height, and to withdraw buildings from the Building Safety Fund and other funds, and to refund those funds who have been responsible for them. Fast forward to January 2023, the Department for Levelling Up Housing Communities asked for developers who had signed up to the pledge to then enter into the developer remediation contract by the 13th of March of this year. And as of the 2nd of May 2023, 47 major developers have signed up. I believe it's now 48, with only 3 holdouts. The contract itself is a detailed form, 112 pages. Relates to residential mixed-use buildings 11 meters and higher. And they are obliged to identify buildings requiring works, to undertake at their own cost all necessary remediation works, and for buildings which are eligible to be transferred out of the Building Safety Fund, and for developers to either remediate it or to refund it. It also includes provisions as to associated entities, so that company and corporate groups are also caught as well.
And which developers are going to be caught by the scheme?
So looking at the scheme in outline, we had the draft regulations published on the 25th of April 2023. They're due to be brought in, the government says, in early summer. So I imagine it could be either June or July, so very shortly. And there's three types of developers who are going to be caught, 2 involuntarily and 1 voluntarily. The first one is where your principal business is residential property development, and you developed refurbished 11 meters high or taller residential buildings in England in the last 30 years, and you meet the profits condition. So in the financial years ending 2017, 2018, 2019, your profits were £10 million or higher. The second part of it is where you have met the profits condition, and you refurbished 2 or more buildings which have now been deemed to be eligible for a government cladding remediation scheme. And then finally, you can volunteer to sign up to the scheme. So effectively, it's going to be larger, profitable developers who have either been developing these buildings as most of their business, or whose buildings have already been caught under the relevant government schemes.
What's the consequence of not signing up?
It's pretty draconian. As Michael Gove told the House of Commons, if you're eligible for the scheme and you do not sign up to a member of this scheme, then it's time to find a new business. Because if you are or could be eligible to be a member of a scheme and you don't sign up, or if you've signed up to the scheme but your membership has been revoked, such as, for example, if you haven't kept to the contract, then you're no longer allowed to carry out development, the meaning of the Town and Country Planning Acts, and you're not allowed to apply for planning permission. You're also not eligible to serve a series of notices in respect of building control. There are numbers.
Isn't it?
It's incredible the idea that you might be able to own land, and yet as a consequence of this, you're not eligible then to actually develop it or do anything with it.
Think about it, 20 years ago, people were successfully arguing you had no liability because you managed to assign your contract to a company that had no assets, and able to avoid liability. The thing has gone. I'm not saying it's a bad thing. I can see it's in many ways a very good thing, but in terms of socio-politically, but the whole spectrum has gone round and round and completely different.
It's, yeah, I mean, Sam Jones and I have recently written a paper for the SCL on this, and it's a complete sea change to what we saw after Murphy and Brentwood. We've gone from very narrow duty of care to being, if you don't sign up voluntarily to this contract, then you can say goodbye to your property development business.
It's quite interesting because Anns and Merton, when it came in 77, was regarded as opening the floodgates, much like this, nothing like as draconian, but the same sort of effect. And then the courts then took the next 20 years to row back from that, ending up in DNF estates and Murphy and Brentwood. And all of that, for a lot of this, effectively, the mood of that has been completely and totally torn up and replaced with this.
Absolutely, absolutely. And I think the idea being that the developers is sort of shifting the onus from leaseholders to remediating buildings onto developers who are better placed to undertake this kind of litigation dispute resolution. In one sentence, what do you see is happening in the next 12 months, 2 years in this area? In the next few months, everyone is going to sign up and frown about it and get on with it. We're then going to see quite a serious consultation, I suspect, but whether that financial contribution goes down from £10 million, profitability goes from £10 million, and it's reduced to catch smaller developers moving into the future. I think that's where it'll go. Marvellous. Finally, when I'm an advocate and a judge hears that, I know they all wear their hearts sleep, but I'm sure that having had such a marvellous seminar, you'll all be just disappointed we're coming to the last of the contributions. We have Samuel Burrett, who is going to give us a whistle-stop tour about the insurance implications. He was also junior counsel for the Grenfell inquiry, focused on fire safety, fire risk assessment, and the action of the London Fire Brigade. And outside the inquiry, he has a busy practice in all sorts of property damage cases, defective construction work, defective construction products, fire, floods, weather and subsidence, the sort of case that used to involve that hotel floating into the sea in the middle of Scarborough, the sort of wide range of property ones where fire now forms a big part of it. Sam, can you just tell us why it is insurance, why you think particularly insurance matters?
Yes, thanks, Paul. Good morning, everyone. Well, it's a fairly obvious and crucial consideration for those who are active in the construction industry as to how the insurance market will respond to the changes brought in by the Building Safety Act. Plainly, the changes have potentially significant ramifications for the availability, extent and cost of professional indemnity insurance. And I think at this stage, it's too early really to say exactly what the impact will be, so we'll need to watch it closely, but it's essential that anyone who has new or additional potential liability by virtue of the Building Safety Act understands the implications for their insurance protection and their level of exposure. And the reason that the changes brought in by the Act are a concern for construction professional indemnity insurers is that they result in a raft of additional or new potential liability for those involved in the construction industry, which in some way, shape or form need to be insured against. And it's not entirely clear that a great deal of consideration was given prior to the enactment of the Act to the question of whether professional indemnity insurers were going to be willing to underwrite that additional risk. Presumably, it was simply expected or anticipated that they would, but given the far reach and the breathtaking nature of the changes brought in, that seems far from guaranteed. What I've set out on the slide here are three significant areas of additional or new potential civil liability for professional indemnity insurers to consider. To be clear, I focused here, for want of time, on potential civil liability only, rather than any regulatory or criminal liability arising under the Act. There's no time to go through these in any detail at all, so I'll just rattle through them. But the short point about all of these areas is that you can see from the extent and breadth of the changes brought in that the scope of insured and insurable risk has massively widened. Number one, there are new and expanded causes of action. Kate's been through the first in respect of defective construction and cladding products. We all know about the expansion of the DPA. The point to note about Section 38 of the Building Act is that provision has still not come into force. It was anticipated that it would come into force on the 28th of June in line with the rest of the changes, but hasn't as yet. So we have to watch that space. The second of the new remedies, Sam Jones has touched upon remediation and remediation contribution orders. We've got building liability orders as well. And over the page, the most perhaps publicised and controversial are the extensions to the limitation periods, which have been discussed in brief already. I think for insurers, it's fair to say that the prospective 15-year extension was concern enough, but the 30-year retrospective extension in respect of Section 1 DPA claims for remediation orders and for defective cladding claims has been an especially worrying development, given the potential revival of who knows how many claims dating back to the early 90s that had previously been removed from their books as time barred, and given all the attendant evidential problems defending such historic claims. I think the point about all of that for insurers is that no one quite yet knows the risk and impact of those new or additional potential liabilities, save that everyone assumes that there's inevitably going to be a significant increase in the volume of claims, not just because of the changes brought in, but just because of this, as it's been described, mood change, where there's a culture of much greater scrutiny of construction work in a post-Grenfell era.
There was some very interesting having to get out old policies and see whether they applied when made or whether their claims made, whether they had time limits on them. You can see that there is real scope for things that were thought to have disappeared to be reviving themselves.
Yes, that's right. I think there's going to be potentially a lot of coverage disputes about whether or not policies will provide protection against such historic claims, which will be an interesting issue going forward. I think plainly it's going to take some time for the new legal landscape to settle and for the likely incidence of these civil claims under the Act to become clear. And I think that uncertainty in the meantime is creating a real difficulty for insurers who offer and price their protection on the basis of a clear assessment of the risk involved and therefore a clear understanding of their exposure. And the concern at the moment, or the difficulty for them, is simply how to balance that risk.
I think at the end of your talk, I wonder if you could go straight to that. You identify 9 questions of things that maybe affect. Yes, there we are. I wonder whether you could just quickly run through those to conclude our morning's deliberation.
Yes, of course. I think the first 2 are fairly self-explanatory. I should say I think all of them are in effect a response to insurers perceiving that there is a far greater risk. First 2 are fairly self-explanatory. The third, high levels of self-insurance, that may well be a consequence of insurers demanding larger self-insured excesses, or simply companies or individuals reviewing their exposure and insurance protection and considering that they need to set aside for more for potential claims. So, for example, if insurers exclude coverage for historic claims beyond previous limitation periods in policies, which we're beginning to see a little bit of, then everyone's going to have to carry out a fairly careful audit, as you suggested, Paul, of previous projects to ascertain, so far as possible, their exposure and to set aside sufficient financial contingency. Exclusions, I've mentioned. Some policies are already excluding historic claims, which previously would have been time barred. We may see that similar exclusions are introduced into policies in respect of other areas of new or additional liability. The consequence of that is point 5, which is that a market may well develop for bespoke insurance coverage to deal with these new areas. The reality of that is one assumes it's going to be very expensive indeed. 6, more coverage disputes. Just to give an example of that, UK professional indemnity market responds on a claims made basis. So if it's the policy in force at the time the claim is made, which may provide cover, So if subsequent exclusions have been introduced, as we anticipate they will be, the claims may not be covered when a policyholder thought they were, and it's likely to lead to disputes as to whether or not a claim is caught by an exclusion, as you suggested, when notifications are effectively made. 7 and 8 are anecdotally, I would say that we're already seeing in our caseload increased effort.
Yes, I'm sure I am, certainly.
Liability. And the final one is perhaps a bit depressing and apocalyptic, but it may be that some insurers simply say that the market is no longer worth their investment. I think the whole point about that, just to finish on, and it's perhaps a slightly rosier point, is that much is presumably going to depend on whether the further regulations and guidance to come and how claims are resolved by the court, and particularly whether, as things progress, the data shows that the objective, the aim of the Building Safety Act is being met, namely whether it is affecting a radical culture change in the industry, which is producing safer buildings. If it does, one assumes that insurers are going to be more than happy to underwrite their fair share of the additional liabilities, because it would then be a much rosier long-term picture for them. If it doesn't, then what we have is an imposition of an enormous amount of additional or new liability on the current culture and model, the sort of quick and cheap culture and model, and that, I suspect, is going to spell real difficulties and lead to some of the issues which I've highlighted in this page.
And some of these businesses' accounts are going to be fascinating to have to analyse, bearing in mind the provisions they're going to have to think about making for potential future liabilities, as I know some of them already are. Thank you very much indeed, Sam. That concludes the 6 talks, and as if by magic, my 6 colleagues then reappear on the screen and click, click, click. It's marvellous. On all of your behalves, I thank them very much for their contributions. I'm sorry that we have run over by 8 minutes to the hour of the hour, but I was reassured by the fact that so many of you stayed online. Reflection of, I hope, the interest that you had in the high quality contributions that we've been lucky enough to have from our 6 panelists. I think the takeaway for me is 2 things. It's still astonishment every time we look at it, at the increase and breadth of the liability, and both in terms of number, size, limitation. Wherever you look, it's even bigger than the last time you looked. Secondly, that we are now moving into the proper phase of implementation. We are now seeing cases, we are now seeing people taking advantage of implementing the provisions. It's going to take a while to bed in, because, you know, once A, keeping the whole picture in mind is not straightforward, and B, the detail inside the picture is also requires great detail. I'm very pleased that 39 is taking such a clear initiative in this fire area and introducing its cross-disciplinary, cross-sector skills, which I hope will be of help to our clients and their associates. So may I then just please say thank you very much to them again, and goodbye to all of you, and invite my panelists to say goodbye to all of you too.
Thank you.
Goodbye.
Goodbye.
Thank you.
Wasn't it the 2 Ronnies where it's goodbye from me and it's goodbye from him? Thank you all very much. Goodbye.
Goodbye.